Let's talk about private membership associations. Hello, I'm Angie Taylor, and I am a certified senior PMA advisor with PMA Power. I have supported breastfeeding, pregnant, and birthing women since 2003. I also obtained 2 degrees in natural health in 2011. I learned about PMAs in 2012, and by the way, PMA stands for Private Membership Association. It also happens to stand for Private Ministerial Association. And because we want to uh, reduce as much confusion as possible, we have started simply saying PMA/ministry. Now, I knew one day I wanted to establish my own PMA and spent 10 years searching for the right person to support me in this endeavor. During this time, I used someone else's PMA until they chose to dismantle it in 2020. In 2021, a friend of mine, Amber Sensala, started posting about PMAs and how she helps others establish their own. I attended one of her webinars, had a consultation with her, and established Land Bountiful Ministry in April of 2022. I now guide others through the same process, and I have a specialty in business activities that support birthing families. Today, I will share making important life choices, the hierarchy of laws, where birth service providers fall in the hierarchy of laws, PMA defined, types and examples of PMAs and their differences, constitutional validation of PMAs, transitioning current business activities to a PMA, costs involved, what's included, and how to get started. While the majority of this information will focus on the Constitution of the United States of America, this information does not only apply to those of us living in the United States of America. There are documents, although not as firmly planted as the Constitution of the United States of America, that support this information for everyone around the globe. You are responsible for your own educational journey. Places to start include the Universal Declaration of Human Rights, or UDHR. This is a milestone document in the history of human rights. It was drafted by representatives with different legal and cultural backgrounds from all regions of the world. The declaration was proclaimed by the United Nations General Assembly in Paris on the 10th of December in 1948 as a common standard of achievements for all peoples and all nations. It sets out for the first time fundamental human rights to be universally protected, and it has been translated into over 500 languages. The UDHR is widely recognized as having inspired and paved the way for the adoption of more than 70 human rights treaties applied today on a permanent basis at global and regional levels, all containing references to it in their preamble. Canadians also have the Canadian Charter of Rights. We all know there is a right way and a wrong way to do things. We also know that we can choose to remain ignorant, or we can choose to educate ourselves regarding the realities of the world in which we live. The bottom line is that we all have important life choices to make. Some of those choices are more critical than others. In business, one of the most important choices has to do with establishing a PMA for our business activities or projects, and most of us don't even know that. Let's dive into some information that is vital to understand, especially if you currently believe the answer for midwives lies with approaching the state and or federal governments and asking for specific protections. To understand private membership associations, we first need to understand the hierarchy of laws in the United States of America. The hierarchy of laws is as follows. We have scriptural authority. This includes God's law and natural law. And whether you're religious or not, this exists and benefits you. I'll explain further in a little bit. Then we have the state constitution. Each state has one. The original 13 state constitutions were used in the creation of the Constitution of the United States of America, which was originally declared by the founding fathers and mothers of this nation. Lastly, we have statutory law as written by the Bar Association. Now, a lot of people today are used to thinking that the federal government of the United States of America is, quote unquote, the top dog in terms of the law. That's actually inaccurate. The laws set forth by the federal government are, in fact, not the supreme law of the land when it comes to the United States of America. If you go back to the true hierarchy of laws, our founding fathers and mothers agreed that scriptural authority, which again includes God's law and natural law, had authority over all mankind. They knew they didn't want anyone else to ever experience what they had already experienced, and that scripture, which again includes God's law and natural law, was older than all of them. So they started there. It's one of the many things on which they explored and discussed, and then found common ground. Now, this is all laid out in the book titled Original Intent, the Courts, the Constitution, and Religion, written by David Barton, which is a great place to start your investigation into why our nation was founded the way it was founded. Then, we the people created our state constitutions. Each state's constitution is what created each state government. And then the delegates in each of the 13 original state governments created the Constitution of the United States of America using bits and pieces of their own state constitutions, knowing that each state government would have power over the federal government they were creating. Let me say that again. They knew that each state government would have power over the federal government they were creating. The Constitution of the United States is what created the U.S. government. The U.S. government then created the statutes and regulations known as statutory law, as written by the Bar Association. So why are the laws set forth by the federal government not the supreme law of the land? Well, it's simply because the created cannot govern over the creator. To understand PMAs, we need to understand not only the hierarchy of laws in America, but also where we fall within them. Currently, it appears as though the spoiled child is holding all the cards, and here's what I mean. The federal government was created by the states, and as they came together in unity to give specific and limited rights and privileges to it. So in this sense, the states are the parents, and the federal government is the child. Right now, the federal government only has authority over states by way of blackmail. They say things like, you will do X or we will not give you money for Y. And instead of figuring out how to accomplish Y on their own, states have been kneeling down and accepting the terms of this deal. Case in point is that one of the rights the federal government has usurped is education. This is not one of the rights nor privileges given to them under the Constitution of the United States of America. The educating of the children created by we the people belongs to we the people. Now, this scenario also seems to be playing out among we the people, as we see more and more parents giving authority to their own children that does not yet belong in their hands. It's also as we the people give authority of our children over to the state. The moment we do so, we have given away one of our many God-given rights. We the people created our state and established a constitution for the same reason, namely, to grant our state government specific and limited rights and privileges. No one watching this presentation was even there when this took place, which is why it is so important to read and understand your state constitution and the Constitution of the United States of America, and how and why they came to be. This is because your power under the supreme law of the land is found inside your state constitution, as well as the Constitution of the United States of America. Sadly, our states, instead of turning to we the people to explore and discover how to accomplish why, have instead sold us out by acquiescing to what they created, namely the federal government. The toddler, or the U.S. government, is essentially running amok and needs to be corrected by the states and ultimately by we the people. You see, human beings do not have power over our Creator, right? We don't have power over God. We don't have power over nature. Therefore, the federal government cannot have power over the states, and the states cannot have power over you because you created them. Why do you need to know this? Well, this used to be taught in school, but it's no longer taught in government schools because we, the people, paid attention. And during the civil rights movement, the government went, the people know too much. So they took it out of schools. And this is really, really important information because knowledge is power. Without this knowledge, we don't understand the power we have been given by God, that the more than 300 men and women who took time from their lives to secure our liberty by enumerating those God-given rights in a single document did understand. As we go back to living life as we the people by relying on our state and U.S. constitutions, we discover, as I've already said, human beings do not have power over our Creator. The federal government cannot have power over the states, and the state cannot have power over you unless you give it to them. So, as someone who supports women who are pregnant, giving birth, in their postpartum period, or breastfeeding, you may be wondering where you are in this hierarchy of laws. We, the people, created you, or rather, the need or want of what you do. Because we, the people, are the creator, only we, the people, can grant you specific and limited rights and privileges. Therefore, the state has no power to intercede unless we, the people, add that to their specific and limited rights and privileges, like asking the state to license you so you can bill insurance and many other reasons that are not, in my opinion, good enough to voluntarily give your God-given rights away. And to my knowledge, the women we serve have not been afforded the opportunity to be involved in the creation of any state legislation pertaining to what we do. Not only that, there are specific constitutional amendments that protect your right to earn a living and that prevent the state from tying your hands. Let's chat about public and private domains. A properly formed PMA allows one to conduct business in the private domain, without government interference. You enter the public domain when you create a contract with the state, such as an LLC. In a properly formed PMA, you have the authority. The government has no access or authority inside your PMA or ministry. This is your castle, and you are the queen or king. This is your private domain. The government only has authority in the public domain. When you establish a PMA that is an unincorporated ministry or church, you claim additional protections based on scriptural authority. Remember, midwives are mentioned in the Bible, and in one account, a battlefield was cleared so they could cross it in safety. Once upon a time, midwives were the care providers for women and children. It's my opinion that it's time to recreate that. So what is a PMA? So private membership association is formed by men and women who collectively stand and assert their rights to choose for themselves what products, services, or business they will use to live, thrive, and maintain their health and wealth in mind, body, family, and spirit. It removes the ability of local, state, and federal governments to interfere with or regulate your business. This includes removing their ability to demand that you require licenses to conduct your private business. Think of a PMA as your private home. The business that is conducted among family members within the walls of your home is private business, unless you are obviously about to commit serious harm or substantive evil. So these are the different types of PMAs and level of protection. So let's start with your standard PMA. or non-faith-based PMAs. These solely protect your right to privately assemble and do business in the private, which is still a really big deal. But for most of the people that I work with, they live their lives according to their faith, which by law, the definition of faith is a firmly or strongly held belief. Yes, that's it. That is the complete definition. So your firmly and strongly held belief could be in God, the universe, Mother Nature, Earth, or even in a tree in your backyard. And no one gets to determine if your faith is legitimate or not with a faith-based PMA. And with a faith-based PMA, it protects your private domain, and it protects your ability to invoke your religious liberties. That is your First Amendment rights. Now, both standard and faith-based PMAs tend to be more singularly focused. So if you're a healthcare practitioner, for instance, or if you want to do some kind of homeschool or preschool daycare, something along those lines, it's much more singularly focused. If you're a big dreamer like I am, and you have multiple passions that are your life's purpose, your ministry is serving others with all of these different things. You're probably going to want to lean more toward a ministry if that's in alignment with your belief system. A ministry is simply when you use your purpose and your God-given skills to serve others. That is what a ministry is. I know traditionally we are used to associating ministries with Christian churches, but that's not necessarily the only case. If you are fulfilling your purpose in life by serving others, that is your private ministry. The benefits of a ministry are numerous. You have a lot of depth and breadth to the structure. You can have multiple business projects or activities within one umbrella ministry. You also have the highest level of protection by having the ability to invoke scriptural authority. That goes back to biblical law or ecclesiastical law. One of the other biggest things is you're able to lean on both the case law that protects all of the private domain and all of the case law that has ever protected ministries and churches. So while there's still a plethora of case law that protects the private domain with a ministry, you get to double up on the amount of case law that you can lean on. There are multiple types or niches within the standard and faith-based PMAs. You're going to have your private membership associations or a PMA, a PEA, which is a private educational association. PHA is a private health association, just to name three. So there is a lot of variety, and you can do mixing and matching. With a ministry, you can cover all of the options under one umbrella if that's in alignment with your beliefs and your purpose. That's why a lot of people end up choosing a ministry. So they can protect, for example, maybe their kids' education as well as their own interests and activities. So isn't it great to know that our liberty still exists? Here are some examples of PMA types, and these are more common than you may realize. They've been around for a very long time. So we have faith-based associations such as churches and ministries. Most churches have registered with the Secretary of State under the 501c3 tax code, so the IRS recognizes them as tax exempt. But doing so means that they are, one, incorporated, two, registering as a nonprofit charitable organization, which a church by definition is not. This is ironic since churches by definition and by default already have a mandatory tax exception from regulations placed upon them, which is protected by the 508c1a and 6033a3a tax codes in congruence with the First Amendment of the Constitution of the United States of America, as well as the equivalent in each state's constitution. Remember from the First Amendment that Congress shall make no law, and this means no law. Okay, so you are probably aware that there are places where members need to sign a private membership agreement to participate. There are fitness centers, health and wellness centers, chiropractic offices, and the like. There's also home based education for parents who want to take charge of their children's education. Restaurants, this is where all customers become members of the PMA, and service is issued on a private member only basis. So, for example, you might see on their menu, you are agreeing to membership when you transact with us. A $1 membership fee is included in your order. And when they operate out of a premises, sometimes they include a sign on the door. So as you're walking in, you will see this is a private members only facility. Access is reserved for members only. You are agreeing to membership when you enter the premises. A $1 membership fee is included in your order. So let me define a little bit more the different PMAs and the ministry. So you have a standard PMA. This is where the government has no jurisdiction. You are the king or queen of your castle. It is tax exempt. This does not have a tax exception. This is tax exempt if granted by the IRS. This is the only kind where you may need to speak with a CPA. It would have an EIN category of 501A for banking purposes only, and it would not have employees. It would have independent contractors who would claim their income as cash using Schedule C. Then you have a private health association, also a type of PMA, but it focuses on health. This functions in private and not in public, therefore has no obligation to and immunity from public laws and regulators, including local, state, and federal, including the FDA. Exception is clear and present danger or danger of substantive evil. So, for instance, if someone comes to me and they would like to establish a PMA that is essentially a murder club, no, they don't get to do that. Provider may have partnering entities, so one in the public and one in the private. So you could have an LLC in the public, you could have the private ministry. Faith based associations or faith based PMA, as well as a ministry or church, has the EIN category of 508C1A for banking purposes only. They would have independent contractors and not employees who would claim their income as cash using Schedule C. They have a mandatory tax exception, so they do not ask for permission and become tax exempt. They have a mandatory tax exception. There are no employees, there are only ministers and contractors. They may issue tax deductible receipts to donors, and property can be tax free held in the name of trustees of ABC Association and their successors. Then you have the Private Education Association. Again, this is also a type of PMA, but it focuses only on education. Parents have a fundamental right to educate their children. There is case law on this. These are just three of the instances that one can cite and draw from. Feel free to look these up. They're a matter of public record. You can read through them and start learning what you need to learn. You do not have to follow state or homeschool regulations, just so you know. Independent contractors, again, are not employees. They claim their income as cash using Schedule C. Parents would send a letter of intent to the school. You don't just pull your kids out without letting the school know what's going on. That can get you in trouble. You would send them the letter of intent, and it would say something along the lines of, "We hereby relieve you of all responsibility for the education of our children, which we are hereby assuming in full." So the constitutional principles that validate PMAs start with the First Amendment. This guarantees freedom of speech and the right of assembly, such as when gathered for a birth in a private residence. Would not apply in any public places like hotels or non-PMA birth centers, hospitals, etc. The Fourth Amendment guarantees freedom of unreasonable searches and seizures. The Fifth Amendment guarantees due process must be part of any proceeding that denies life, liberty, or property. The Ninth Amendment guarantees certain inalienable rights to every man, woman, and child that have not been enumerated in the previous 8 amendments. The 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The 14th Amendment guarantees the right to associate with fellow members and to offer benefits and services that are outside of the jurisdiction, venue, and authority of the state and or federal authorities. Now, I highly recommend reading the book Legal Guidelines for Unlicensed Practitioners, written by Dr. Lawrence Wilson. On pages 110 through 112, it reads, starting with the second paragraph, in Griswold v. Connecticut, the Supreme Court held unconstitutional Connecticut laws that criminalize the use of or assistance in the use of birth control. Justice Douglas wrote that the statutes violated the right of marital privacy created by specific guarantees in the First, Third, Fourth, Fifth, and Ninth Amendments. This opinion by Justice Goldberg, joined by Chief Justice Warren and Justice Brennan, catapulted the Ninth Amendment into prominence. Justice Goldberg wrote that the framers of the Constitution believed there are additional fundamental rights protected from government infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 amendments. The Ninth Amendment, in indicating that not all such liberties are specifically mentioned in the first 8 amendments, is surely relevant in showing the existence of other fundamental personal rights now protected from state as well as federal infringement. In sum, the Ninth Amendment simply lends strong support to the view that the liberty protected by the Fifth and 14th Amendments from infringement by the federal government or the states is not restricted to rights specifically mentioned in the first 8 amendments. Since the Griswold case, the Ninth Amendment has been cited more than 1,000 times. The most famous case was the Roe v. Wade decision on abortion. The Ninth Amendment was used to support the idea of a right to privacy. Abortion was held to be a private matter. The government could not pass a law forbidding it, even though it might be murder of an innocent child. The early intent of the Ninth Amendment was to protect the states and the people from federal encroachment. The recent use of the Ninth Amendment has been to nullify state laws, especially in the area of morals and sexual matters. Let me just touch on the fact that we know that Roe v. Wade was overturned on the federal level. This was because the Supreme Court of the United States of America did not have the right to hear the case. Remember, they are not the supreme law of the land. These decisions needed to remain in the state. So if you are not happy with how your state is handling this topic, you need to get involved. So does the Ninth Amendment protect just any right? Raoul Berger, in the Cornell Law Review, sharply criticized Justice Goldberg for his interpretation of the Ninth Amendment in the Griswold case. Berger argued that if the Ninth Amendment can be used to protect some vague privacy right, what is it to stop anyone from making up a right and then using the Ninth Amendment to protect it? Who is to say which rights will be protected? This is indeed a difficult question. However, one can argue this is precisely the challenge of the law, to evolve as society evolves. It cannot remain static any more than technology, language, or culture remain static. Judge Goldberg and the other justices made their decision by referring to other provisions of the Constitution to establish a framework or rationale for the unenumerated rights. Indeed, the right to privacy has a good constitutional foundation. It also dates back even further to John Locke's theory that each person is basically his own master. Judge Cooley described this right as the right to be let alone. Are we not our own master? Do we not have the right to be let alone? The Ninth Amendment and unlicensed healers. I was unable to find evidence the Supreme Court ever took up the question of whether state medical practice acts violate a right to privacy, the right to associate and contract freely, or the right to protect one's bodily property. Until there is a definitive case, it remains an open question. I believe there is clearly a privacy issue involved in the right to offer and receive one's choice of services in healthcare, education, psychology, and legal matters. Such services may be every bit as intimate and important as birth control or abortion. Pregnancy and birth falls within a woman's right to privacy. Her requesting the support of others falls within her right to associate and contract freely, as well as the right to protect one's bodily property, doesn't it? And if you're like me, you can see in this last paragraph exactly how we can stand up for ourselves, and especially for the families we serve. Because when we give away our rights, we are also giving away their rights. We have no expectation, in my opinion, to be licensed and be given the right to be in their home, because we are coming in with the state. And quite honestly, we need to stop bringing state and federal government into the family bed. Okay, so you're probably wondering, okay, well, what do I need to do in order to prepare for establishing and operating a PMA or ministry? If you're closing a practice, you want to make a list of all obligations to parties under your practice. This may include state authorities, suppliers, creditors, insurance companies, DEA, state licensing agencies, state employment agencies, payers such as Medicaid, TRICARE, referring physicians, hospitals, landlords, accountants, attorneys, insurance companies, and other parties. Notify each of the closure of your practice and the date of the closure. Find out how long records must be maintained as specified by state and insurance companies, etc., and prepare to file and store accordingly. If you're closing a business, such as an LLC or a sole proprietorship, you need to make sure that you do your accounting and tax reporting, prepare a final balance sheet, and file a final return and related documents with the IRS, pay owing taxes, cancel your EIN and business with the IRS, notify customers and all impacted parties. Then you're going to finalize employees, taxes, wages, deposits, pension plans, and benefit plans. Report payments made to contract workers, settle all obligations. You're going to finalize and store all records according to legal requirements. Do not just allow a license to expire. Tell your state you are dissolving or canceling your license, essentially giving it back to them. So here's a checklist for starting a PMA or ministry. The things that you need to be aware of. These are the first few steps. You have to choose a PMA. Are you going to do a faith-based PMA? Are you going to have a health association, an educational association? Or are you going to have a ministry? And will it be a faith in God ministry or a faith in nature ministry? If you have assets, highly recommend that you form an ecclesiastical trust that operates as a ministry. Then you're going to choose the name of your PMA. Respect existing trademarks and names. You're going to search Google, TESS, which is trademark registration. Also look at domain name registration sites to make sure that the name that you want is not already taken. Then you will need to choose your trustees. You will need a chairperson plus one or more co-trustees to assist in operating your PMA or ministry. Inform past and future members. A signed membership agreement is recommended. Obtain your EIN. This is for banking purposes only. It's not going to be used for anything else. And you only do this after your founding documents have been completed. Otherwise, you are committing fraud. So what is the cost? For an ecclesiastical trust that operates as a ministry, this is $3,200. So this is, again, you would get a private ministry as well as a trust, and the trust is for asset protection. So the trust owns the private ministry. And I explain all of this to those that are going to establish this type of entity. Then you have a private ministry, whether it's faith in God or a faith in nature. This is $2,400. Remember, this is more flexible. You can have a number of different business activities or projects within an umbrella ministry. And then you have a faith-based PMA. So this would be a member association, an education association, a health association, a private business association, etc. And these are $1,800. I will tell you that anyone who establishes a private ministry with me, depending on what their primary business activity is. So, for instance, when I am speaking with a midwife, I do include a private health association. And then we talk about how you're going to use everything. This does include a PMA Founders Guidebook, which is both as a PDF, but also a course on my website in a private members area. Then you have a private members only community, as well as the ability to be on the directory listing. Now, several sources will happily create PMAs for you that are statutory compliant, and they will charge you more. What does that mean? That means they have not done anything to change your jurisdiction from public to private, and that matters. So here's my promise: when you allow me to guide you through the PMA ministry creation process and refer others to me, and they do the same, my private ministry, Land Bountiful Ministry, will make a donation to your PMA or ministry. So the choice is yours. Yes, life does confront us, and the challenge is the right knowledge and the right action is what will carry us through. Do you want to keep your business private and shielded, or public and exposed? Now I'm going to answer the most frequently asked questions for you. Will establishing a PMA keep me from being arrested? No. Establishing your own PMA will not keep you from being arrested. Absolute protection from being arrested and or charged for anything does not, nor will it ever exist. There's also a very big difference between being charged and being convicted. This is also true when you have a state license and or certification from a quote unquote approved organization. The only thing that can significantly lower your risk of being arrested is for you to carry nothing you do not have the right to carry, do nothing that is known to increase risk to those you serve, use your practice guidelines, contracts, intake, and consent forms to reduce your risk, know what you need to know in order to serve families safely. If you do not know how to handle emergencies, do not serve birthing families. And be honest about your education, skills, and training. Also, document everything. All documentation is private within a private health association or a private ministry and cannot be subpoenaed. Okay, documentation is very important. What if I do establish a PMA and I get arrested? Step one is to remain calm. Step two is to claim all of your rights, known and unknown. These include the right to remain silent, the right to a phone call, the right to an attorney, etc. Number three, do not attempt to explain to them that you function in the private domain because they won't understand what you're saying. And step four, know who to call. Okay? If I'm the one who drafts your documents, you reach out to me first and we go from there. What else can I do to prepare and protect myself? I've already said, read and study your state's constitution and the Constitution of the United States of America. Watch, listen to, and read anything from Chris Ann Hall. I suggest starting with the non-compliant movie, and then the part two of it is the sheriff. So you can go to libertyfirstsociety.com/non-compliant movie. Read. Now, this is not an all-inclusive list. It's just a place to start. Read Making Midwives Legal, Childbirth Medicine and the Law, Legal Guidelines for Unlicensed Practitioners, Fruit from the Poisonous Tree, Cracking the Code, The Fascinating Truth About Taxation in America, and the Right to Earn a Living, Economic Freedom, and the Law. States with licensure have defined midwife. Does that mean I cannot refer to myself as a midwife? No. No one owns the word midwife. You get to define what midwife means to you. I personally am choosing to reclaim the word midwife and return it to its original definition of with woman by practicing in a way that proves to the women I serve that I have no other allegiances. Also, currently, there are a lot of people confused about the differences between the terms midwife, doula, and birth keeper. I believe it is important to clear up that confusion because a doula is not a less expensive midwife, and leading women to believe that it is, in my opinion, unethical and harmful. This is also not about rank or hierarchy. This is about education, experience, and skills, and being honest about what you know and how you can support them. What about the recent call for midwives to join together and seek federal legislation for traditional and indigenous midwifery? Wrong direction. If I could yell that and not blow out your eardrums, I would. We need to learn how to secure our rights that are enumerated in the Constitution of the United States of America. We need to understand the Constitution for the state in which we live. We need to stop operating from a place of fear and come to understand the foundation on which we already stand. The founding fathers and mothers of this nation expected us to absolutely rely exclusively on the Constitution. They even included an amendment for the God given rights they hadn't specifically listed. We, the people, have those rights unless we choose to give them to the state or federal governments by doing things like asking for legislation to quote unquote protect us. The entire goal of the founding fathers and mothers was to do the very best they could to create something that would protect us from government overreach. Sadly, we've come to a place where everyone seems to think that the state and federal governments need to legislate everything under the sun in order to protect us, without understanding that when we do that, we give away our God given right and exchange it for permission and licenses that can be revoked, pulled, or canceled at any time. What's truly sad is that most of us don't even understand that licensure in and of itself is government overreach, especially when it comes to all the things related to birth. So stop inviting the state and federal governments into the family bed. Let's remember too that protections for midwives goes back further than the founding of this nation. We have biblical roots, and that really does matter in every nation on the planet. What we do predates every government ever created by humans. Yet, so many are still seeking for someone outside of them to tell them what they do is legitimate. Here is a fact. The fact is that the man-made baby delivery system needs to prove its legitimacy to midwives, because what we do came first. And by the way, you're going to hate me for this, possibly, but you are part of the man-made baby delivery system if you believe all things related to birth are medical. Do you know that just because someone like a midwife gets charged with something, it does not mean she cannot provide services to others while she's being investigated? Do you know that it's also not her job to help with the investigation? Do you know that even if a state agency sends a cease and desist letter, they still have to have jurisdiction before the letter is valid? Do you understand jurisdiction? Most of us don't. And it is really starting to bite us in the rear. How do I protect myself from being arrested for practicing medicine without a license? So one of the hurdles we all face, regardless of where we live, is that the practice of midwifery is not the practice of medicine, because the normal, natural, physiologic process of a woman's body is not medical. And the Kansas State Supreme Court agrees with me. You can see the State Board of Nursing and State of Kansas State Board of Healing Arts versus E. Michelle Rupke. Just search for it. It's a matter of public record. Essentially, what the verdict came down to was that anyone in the state of Kansas who supports a pregnant or birthing woman cannot be arrested for practicing medicine without a license because these processes are the normal, natural, biological, and physiological processes of her body. Now, with this amazing state Supreme Court ruling, this still does not mean that those supporting pregnant and birthing women cannot ever be arrested and are charged for anything. It just means in the realm of practicing medicine without a license, because what we do as midwives is not practicing medicine. It is my opinion that those processes should not be covered by medical insurance, and therefore there should be no medical codes for those processes. Now, some of you are probably asking yourself, but what about fill in the blank? And my answer to those questions about when the normal is no longer normal and is not responding to things like nutrition, increase in salt, hydration, rest, etc., then and only then does it become medical. That is when we transfer care for the benefit of the woman because her body has proven it needs what medical providers offer. All things related to birth seem to come down to an education problem and unwinding the things that have been put in place by those who have little to no knowledge about the normal, natural, physiologic processes of a woman's body because they deal primarily with the instances when those processes are no longer normal. In essence, we are talking about the same topic while speaking two separate and distinct languages. If you want to establish your own PMA, you would work with someone like me, who is a PMA advisor, and I do the drafting of the founding documents to establish your PMA or private ministry. And the reason that's important is because, yes, we do have the private domain, and we want to create legitimacy and a structured establishment in the private domain. And that's what the founding documents do. So someone like myself has been taught how to properly draft these documents. And all that I'm doing with the PMA is taking the privacy you have in your own home with your family and expanding that circle of trust and that circle of privacy and giving it a structure and legitimacy. If you would like to speak further with me on this topic, send an email to Angie@landbountifulministry.org. I look forward to meeting you.